India development debate. Are repeated judicial interventions coming in the way of legislation and development? At least that's what the government claims, coming harsh on the policy overreach of the judiciary. Attorney General KK Venugopal told the Supreme Court yesterday that the top court has acquired vast powers and has in fact become the most powerful court in the world. Speaking before a 5-judge bench, he said the apex court has added at least 30 rights to the fundamental rights, virtually hijacking the lawmaking function of the government. And the court has hit back, saying that it cannot remain a mute spectator to matters relating to social welfare. The standoff between Parliament and the judiciary is nothing new, but what is surprising is the aggressive manner in which both sides are approaching the issue now. We at ET Now raise some big questions in the India development debate today. Is judicial overreach coming in the way of development? Have the flip-flops by the top court led to policy uncertainty? On the other side, can courts remain silent when it comes to matters affecting people's life and rights? The judiciary versus parliament standoff, that's the big topic of debate on the India development debate. And joining us is a stellar panel of experts. Frankly, we couldn't get a panel better than this. We've got Mr. Soli Sorabji, constitutional expert, former Attorney General, Mr. Mukul Rohatgi, Senior Counsel and former Attorney General for India, Ms. Pinky Anand, Additional Solicitor General, Sanjay Hegde, Senior Advocate, Supreme Court of India, and Satvik Verma, corporate lawyer and columnist. Thank you all so much for joining us on the India development debate. Mr. Sorabji, I'm going to start off with you because you've seen this tussle play out over several years, if not decades. What do you make of this standoff now and these strong comments coming in from the current Attorney General saying that he believes the Supreme Court has acquired vast powers and in fact is the most powerful court in the world? Do you think that there has been judicial overreach over the last few years, maybe even decade or so? What's your sense, Mr. Sorabji?
Well, I don't think there has been judicial overreach over the years. In some cases, some orders may go beyond the bend, but on the whole, there is no judicial overreach. And if there is judicial overreach, I think it's all the better if it means the protection of fundamental rights of the people, especially the people who are unable, marginalized sections of society, in which case the court may well intervene, and very well executive may not like it, but that's the whole question. When the executive doesn't do what is required to do, Parliament doesn't pass the laws, then the judiciary can't remain a mute spectator. It can't fold its hands and say we will do nothing. So I think on the whole, there has not been judicial overreach, and if there has been, it's all for the good.
Right. Mr. Rohatgi, do you agree with the view of your successor that the Supreme Court has become too powerful and acquired vast powers, probably what was envisaged in the doctrine of separation of powers?
I endorse that view completely.
Why do you say that, Mr. Rohatgi?
If you see the Constitution, our Constitution is based on separation of powers. So there are 3 compartments in the Constitution. One is the judiciary, one is Parliament, and the third is the executive. So the judiciary is supposed to decide disputes between parties. The Parliament is entitled to make laws for the country, and the executive is to carry on governance, whether it's union government, whether it is state government, whether it's a municipality or whether it's a panchayat. Unfortunately, if you see the trend after 1985 or 1990 onwards, the judiciary is slowly encroaching on the 2 other spheres which is prohibited by the Constitution. And today we have come to a pass that under the label of public interest litigation, the court is now monitoring the construction of dams, the height of the dam. The courts are talking about interlinking of rivers, whether we have diesel cars or whether we should have petrol cars. All that is now decided by courts. In fact, the courts are kind of running the government, running the municipalities, and even in the field of parliamentary domain, the constitutional position is very clear that Parliament is supreme in its sphere and the judiciary cannot have a look or peek into what is happening in Parliament or what kind of laws are being made. So now a new tool has been devised that if there is no particular law on a particular subject, till a law is made, which can be a year or 6 months or 5 years, if the government wishes, if the Parliament wishes to make a law or not, the court then puts in a code of conduct or behavior which is to work as a law across the country based on an order of a court till a law is brought in.
Right.
So there is no doubt that one sphere has now kind of overshadowed the other two spheres.
Okay, Sanjay Hegde, comment on that. Those are very strong words coming in from Mukul Rohatgi. He's saying that the courts are running the government, they're even running municipalities, and there is no doubt about the fact that one sphere is overshadowed the other spheres, obviously indicating both the executive and the legislature. Sanjay Hegde, how would you respond to that?
Well, courts sometimes are called in to run when governments don't run. When people don't go and get food, they have come to the courts, and courts have ordered governments to provide food. When there was a lack of a road in some places, people had to come to court. The thing is that there is no other mechanism which can listen to citizens' grievances and render effective action, which makes the government to act. Now, it's always been, every ruler has always had a fight with whoever has had to interpret the law. Many centuries back, Henry II said, "Will no man rid me of this turbulent priest?" Franklin Delano Roosevelt threatened to pack the US Supreme Court with appointed judges. Every ruler who believes that he has divine powers, or that he, by virtue of his parliamentary, his electoral victory, whether it was Indira Gandhi in the previous time who wanted a committed judiciary. Every ruler wants a judiciary aligned with his philosophy or full of yes men. But that's not the judiciary's job. The judiciary's job is to act as a brake on despotism. The judiciary's job occasionally is to nudge the government when there is a lot of inaction. All that the judiciary has done in many cases is to implement government policies. We have all these policies on clean air, but yet governments did nothing. So the judiciary had to step in, force them to buy CNG buses, try and clean up the air in Delhi once. It did succeed for a few years, but then vehicular population exploded, various things happened,
right,
and we are back to a stage where air pollution is at those pre-2000 levels.
Sure.
So therefore, this time in Diwali, the judiciary had to again intervene.
Okay.
All that I am saying is that it is only the written law,
right,
that has been framed by a parliament and the executive's policies that the judiciary nudges the executive to take action on.
Okay, fair enough. You are saying it's the job of the judiciary to nudge the executive to take action. Ms. Pinky Anand, is it the judiciary's job to run a private cricket body? Is it the judiciary's job to order state governments to offer farm loan waivers to the people? Is it the judiciary's job to determine, at what distance in a highway should there be a liquor vending shop or not? Are these instances of judicial overreach, or can this be justified by saying that these are instances where the executive didn't act and so the judiciary had to step in and act?
I'm afraid if the test would ever be to say that the executive didn't act, therefore the courts have a right to act and fill in that situation, it would be reaching into a very difficult and turbulent terrain, so to say. Because ultimately the idea when you have separation of powers and you have three wings is to ensure that each works within its own field depending upon its expertise and requirement to do so. All said and done, the judiciary under the constitution is meant for the purposes of ensuring the resolution of disputes. Social activism is one thing on which, one direction where sometimes from time to time, nudging the government is one thing, but to say that the judiciary can actually put down a matter of policy, or even to intervene in a matter of policy, or to go into domains which should be best left to the wisdom of expert bodies, so to say, I think there is a problem here, and definitely an area which needs to be addressed, because the courts do not have the expertise to do so. A. B. There are conflicting interests of groups of people, of the public. When you have a public, you have a parliament. The parliament represents various groups of people and the interests. I mean, for example, in the environmental issue on the firecrackers, so to say, you have different groups of people which needed to be looked at, different interests which need to be balanced, different expertise which required to be there before any action could have been taken or should have been taken, and particularly on the last minute situation, unfortunately, that it did come around. So I mean, these are indicative of the fact that we need to look a little more closely into where the area of nudging ends and where it starts transgressing into areas of other spheres, including that of the parliament and of the executive. Again, executive failure to action, that is one thing where I don't think there would be much dispute to say, very well, the court said something has to be done in accordance with the policy, as executive was saying, very well, that should be done and implement that. But to legislate a policy, so to say, or to define a policy is something which can be rather controversial, and so much work goes into by the parliament, by the government, to put into place policies and laws, and ensuring the, as I said, the conflicting interests of the public at large and the different interests, that maybe it is something which should be looked at again before we go into this area.
Okay, Sathwik Verma, comment on that. This whole thing of where do you determine, where is it a nudge, and where do you transgress the domain of the executive, and do you believe, what's your view on the debate? Do you believe that courts have often now started playing to the galleries, on issues like, say, whether it's the national anthem issue, or the firecracker ban? Do you see that tendency creep in as well, Sathwik Verma?
Sandeep, I think it's important for us to understand that this is not the first time that this debate has come up on questioning whether the courts are acting in excess of their powers. Mr. Rothke very rightly said that one of the basic structures of our constitution is the separation of powers. But we also need to understand that the legislature, the executive, and the judiciary do necessarily overlap, and that's something that's been going on for a long time. This actually begs the question on whether we need one limb of our constitutional functioning to be subordinate to the other, and whether the subordination is required for the effective functioning of the democracy. In my view, it's not required. They all work in parallel. The one reason why the judiciary has been perhaps getting into some of the realms of policy, and therefore the governments need to be nudged, is because, unlike what was mentioned, I do not believe that there is a substantial amount of time that has been spent on lawmaking. You can pick up multiple pieces of legislation and there are hardly any debates that you will find in Parliament on that. And I think case in point is the medical termination of pregnancy bill, for example. Amendments were proposed and have been pending now for over 2 years, as a result of which multiple cases of abortion very late into the pregnancy are repeatedly found at the door of the Supreme Court. Now, some people may question, do these cases need to be decided by the Supreme Court? Should the Supreme Court be looking at 26-week, 32-week? But the fact of the matter is that there has been a bill that's been proposed that has sought to increase the limit and it's not been passed. So that's one important point. I do agree that certain times when there are social welfare issues that are involved, it is important because it's time sensitive for the judiciary to step in and act. But I also agree that, whether it's the functioning of a private, the BCCI, or whether it's to regulate diesel cars above 2000 cc, those are areas that the judiciary was perhaps compelled to be in, but were also areas, in my view, that could have been avoided.
Have sort of more balanced view on this issue. It's a wonderful panel, as you can see. We've got all opinions covered. But Mr. Sorabji, I'm coming to you on the specifics of the case. And again, the point made by the Attorney General in court yesterday was that he believes the ambit of Article 21 in the Constitution that guarantees right to life and liberty has been extended by the court to guarantee a host of other rights such as clean air, jobs, education, etc., etc. In fact, the Attorney General says that 30 other rights have been read into Article 21. What would you say, sir, to this position taken by the Attorney General?
Well, I think it's a very good, expensive interpretation of Article 21. After all, what is Article 21? It guarantees life and liberty. Now, life doesn't mean merely physical existence. Is the expensive interpretation of this Article 21, which has led to Supreme Court framing many laws, rather than giving many directions which really enhance the quality of life of the citizen. For example, take some cases where there is complete under-trial prisoners, for example. For years, in courts, there are under-trial prisoners. What do? If they were to say we are guilty, they'll get punishment of 3 years, which is shorter than the period they spend as under trial prisoners. Now it's all very well to say doctrine of separation of power. Montesquieu's separation of power is all very well. We have to apply this doctrine in the facts and circumstances in the light of conditions prevailing in our country. And really speaking, the Supreme Court's job is to see that ultimately the person's rights, basic rights of life, as interpreted expansively, not merely physical existence, and liberty are vindicated and done. I agree, at times Supreme Court may get a little overboard, for example, standing up and singing the national anthem, but these are cases far and few between. On the whole, if there is inaction, the judiciary has to be active, and it can't remain passive.
Okay, you're saying
spectator.
Okay, you're saying if there's
That's my
inaction, the judiciary has to act. I'm going to debate that, but I want to get Mr. Mukul Rohatgi's view on this point that you made on the interpretation of Article 21, and you believe that the court, while extending its interpretation, it has done nothing wrong, and that's largely in line with what was envisaged. Mr. Mukul Rohatgi, comment on that. Do you agree with Mr. Sorabji here, or do you agree with what the Attorney General said, that the Supreme Court has, in a sense, added 30 other rights they've read into Article 21 and sort of in some ways misinterpreted that article of the Constitution? Mr. Rohatgi.
See, the articles are very specific and are cast in very specific and clear language by the makers of the Constitution, the head of which was a very intelligent person called Dr. Ambedkar. Now, when a particular article says a particular thing, it is as clear as daylight. So, under the garb of interpretation, you have now included many sub-articles in an article which did not exist. Now, if you take that view, even in the judgment relating to privacy, I had pointed out when I was Attorney General that an 8-judge bench of the Supreme Court had said that privacy as a concept was not enshrined in the Constitution. Now, I can understand privacy as to what is happening in your house or in your bedroom, but to extend privacy to the fact that nobody should know where you are or where you are going, etc., is not compatible with the modern world, which is full of terrorism and other security risks. The court is also, I don't know if you are aware, the Supreme Court passed an order about 20 years ago that if any tree is to be cut in India, permission has to be obtained from the Supreme Court. Now, the law does not say that the Supreme Court will decide whether a tree has to be cut to make a road or not. Now, because of this, as an Attorney General and even earlier as a lawyer, I found that a large number of roads which are crying to be built in the northeast and on our borders by the defense are stuck for a number of years because the matters are pending in court. Whether a railway line can go from a particular place to a particular place, which may involve clearing of some trees, you have to go to a court. Now, this is not what the Constitution envisaged.
Right. Sathik Verma, comment on that. Mukul Rohatgi says it's watertight. The interpretation of Article 21 is clear, it's cast in stone, and it doesn't lend itself to multiple interpretations. Whereas, obviously, Soli Sarabji says has a different point of view. How do you weigh in on the debate, or do you believe that the Attorney General, in some ways, has crossed the Lakshman Rekha by saying the 30 sort of rights have now been read into Article 21? What's your own view, Sathik Verma? I can see Sanjay Agde nodding. I'm coming to you next, Sanjay Agde. But Sathik Verma, you first.
Sandeep, I think we need to understand that we gave ourselves the Constitution in 1950, and even though the Constitution has, for the most part, contemplated everything that could be thought about at that stage, not everything is cast in stone, and therefore some of the extensions that have been given to the Constitution and to our fundamental rights are much needed, and have only been to accommodate the socio-economic changes that the country has gone through. I personally believe that the judgment on privacy is a extremely well thought out and a well deliberated judgment. It also provides reasoning and rationale on the fact that it is a primordial right, our privacy is a primordial right within the confines of Article 21. And we need to understand that even, the much talked about public interest litigation, which our High Court yesterday also termed as political interest litigation in a particular case, it is because of the public interest litigation that the rights of a lot of people have been advanced. And I come back to the point that there isn't a one-size-fits-all jacket formula. When the court steps in, when it is to deal with dengue or chikungunya, or to deal with providing justice for children in conflict with law, or for that matter, providing night shelters in Delhi, I think we all laud it, and that all happens under public interest litigation. But yes, there are certain instances when the public interest litigation itself becomes a tool in the hands of a few people, and we need to really be careful. But not every right could have been thought over. And some of the rights are an extension of the right and have to be with the changing environment and circumstances.
Fair point. Sanjay Agde, comment on that. What's your view on the debate on Article 21, its interpretation? And I'm going to club in another question, which is on Article 142, which is again at the bone of contention, which again the government and the Attorney General believes has been misused a lot. Of course, it's an article that can be invoked only by the Supreme Court, but yet the Attorney General indicates that has been abused way too much. Sanjay Agde.
Well, as far as 21 is concerned, to just say that you have a right to life and liberty and just leave it at that is sterile interpretation. Many years ago, Chief Justice Charles Evans Hughes said we must never forget that it is a constitution we are interpreting. That's in the US context, of course. To reduce everything to original intent and say that whatever is written, you can't go beyond that, that is absolutely sterile and unproductive. You can theoretically keep a man alive and say you have a right to life, but what use is that life if he cannot enjoy clean air, if he cannot enjoy privacy, if he cannot enjoy the right to sleep? And there's so many penumbral rights which have all been read into the right to life. These have, by means of constitutional interpretation, been given as that which gives content to the mere dry words of the Constitution. I don't think any civilized government should object to that. Every government in India seems to want to control the citizen and say that rights are that which we will concede to the citizen. No, sorry, Mr. Governments, that is not how things work. Rights are inalienable parts of which are given to mankind by creation itself. The Constitution recognizes them, and it is the duty of a constitutional government to enforce them and not to abridge them or not to trample upon them.
Fair
It's
enough.
all very well to say that, oh, we are in the government, we know best. We can't have a situation where a citizen can walk off the grid. My point to you is that every citizen has an absolute right of privacy.
Right.
If he wants, he says, to be left alone, he has to be left alone.
Okay, fair enough. Mr. Sorabji, I'm coming to you now on Article 142, which has been an article that has been, many would argue, misused a lot and has been invoked way too often to, to pronounce sweeping judgments. Take the case of the highway ban. Again, a judgment that has had an impact of almost 60,000 crores in terms of revenue to the exchequer. 100,000 jobs have been impacted on an issue where many would argue that the court needn't have intervened. And again, Article 142 was invoked. And I can rattle off a list of other similar judgments. How does the court sort of ensure that the rights of individuals, for example, the people who lost their jobs on account of this judgment, what about their rights? How do you safeguard those rights when the court invokes an Article 142 to make a judgment? What about them?
Well, it's right. Some Article 142, unfortunately, has been used to pass certain orders which are rather bizarre and which may affect the people. But look, see the thing as a whole. For example, do you say where are these rights? Where is freedom of the press in the Constitution? Freedom of the press is mentioned, but the court deduces from Article 91A, and no fundamental right is absolute. So even if this privacy is reduced, it's not absolute in certain cases. At home, of course, it doesn't matter what you eat, with whom you have dinner, but no fundamental right is absolute. Therefore, restrictions can be imposed in public interest. So the whole thing has to be synchronized. I don't understand, because of some orders of the Supreme Court, which may be a little bizarre, doesn't mean that the Supreme Court has become Article 142 should not be used. The order should not be passed. Where is the right to travel abroad and return to your country? Is it there? Supreme Court did it in the Satwan Singh's case. The right to travel abroad and return to your country. Where is it? So that's an expensive interpretation.
Okay.
And the example I gave you was the freedom of the press. Show me where is it in the Constitution. It's not there.
Okay.
Supreme Court has derived it
Okay.
from the guarantee of free speech and expression.
Okay,
I don't see anything wrong in that.
That's a fair point you're making. Let me get in Mr. Rohatgi's view on the Article 142. Mr. Rohatgi, many would argue that the judiciary, has to step in, wherever there is state inaction. But more importantly, your view on Article 142, Mr. Rohatgi, how can the court safeguard the fundamental rights of individuals while invoking Article 142? And there have been several instances, like I spoke a short while ago. How can the court safeguard the rights of individuals while invoking Article 142? Mr. Rohatgi.
Yeah, look, now Article 142 is a very special power which is given only to the Supreme Court, not to the High Courts, that in order to do complete justice, they can sometimes short circuit some procedures. 142 is not an unguided missile that you can use it whenever and wherever and supplant the laws. It is meant to supplement the laws in order to reach out to injustice. So as I told you, you stop, by a stroke of pen, you stop every hotel in the country from serving liquor. So what is the impact? I mean, it's not as if people will stop drinking, right? So millions of jobs are lost. So therefore, the court must consider and take into account all these things, which unfortunately has not been happening, and I have given you enough examples. So it is my sincere belief that the court must introspect and must look at a kind of a legal audit as to what has happened in the last 30 years, what is the impact of its directions on the economy on account of jobs and so on and so forth, and then maybe take a restock of the situation. Like a refresher course. Even lawyers or judges should have refresher courses after 15-20 years. So this kind of a refresher or legal audit is required to see as to whether where you are going is correct or you must retrace your steps. That is what is required.
Profound statement you're making on the need for a legal audit of sorts. I wonder how the judiciary is going to react to that. But Satvik Verma, come in on the point there that was made by Mr. Rohatgi on the fact that you need to save that some of these judgments where the Article 142 has been invoked has had far-reaching consequences, and probably even the court, while delivering those judgments, didn't envisage the sort of impact that these judgments would have in turn. How does one find a balance there, Satvik Verma?
We need to understand one thing which is foremost. It is that it is the constitution and the laws of our country that are absolutely supreme. And an inherent part of that is the concept of the rule of law. Now, do the judges not have the powers to advance the law, to make sure that judgments are correctly implemented? And is lawmaking not an inherent power of judging? In my view, I think lawmaking is an absolutely inherent power of lawmaking, and to that limited extent, for the purposes of doing complete justice, the interpretation that is sometimes given to Article 142 is much needed. But I also completely understand and appreciate, and this is something that the Supreme Court has taken note of in more than a few judgments, that unlike the executive and the legislature, where there are outside mechanisms of control, the only mechanism of control on the judiciary is the self-imposed power of self-restraint. And therefore, we need to necessarily balance the two ends. The one end being the necessity and the inherent power of the judges and our courts to perhaps read in certain laws for the effective implementation of their judgments, or perhaps for the advancement of the rule of law, and balance that with the fact that there is only the concept of self-imposed self-restraint. I'm reminded of this quote of John Locke, who's the father of liberalism, and this is something I've said in the past as well, that whenever law ends, tyranny begins, and we need to always make sure we remind ourselves of that whenever law ends, tyranny begins.
We've got Ms. Pinky Anand back on the line. Apologies, we lost your link there, ma'am. But we were talking about Article 142 and whether or not it has been abused. Now, many would argue that it has been used by the court only whenever there has been a gap in legislation or a gap in executive action. It is on account of executive inaction or on account of policy paralysis that this sweeping article is used by the court. How would you sort of respond to that assertion?
See, all said and done, Article 142 is a residuary powers of the courts ultimately to do complete justice between parties and in fact to the nation and possibly towards social activism, and nobody is doubting that process. But it can't be used as a tool in aid to step in directions which are otherwise safeguarded for other wings of the government, so to say. So, if for example, if it's a law which the parliament is to make, can the court step in and in the name of effective justice put in a law which the government is, let us say, debating upon, and the debate of course could carry on for some time. It may be there is need for the law also, but the various diverse interests are being looked into by the government and the conflicting interests, so to say. So, can the court effectively adjudicate and make a bill or a law? As somebody said, there is an inherent power to make law. No, there is no inherent power to make law. The inherent power is only the rule of law, and rule of law also there is another problem. Rule of law envisages a certainty of law, a law that exists, people know that they are governed by it. If there is a violation of that, consequences would follow, and therefore the rule of law prevails, and in fact there is as such no tyranny. I don't know why there is this constant thing about tyranny and the rule of law. The rule of law itself implies certainty of law. That is one essential feature. So, I think that is also bypassed when there is too much adjudication or steps made in that direction by virtue of such residuary powers like Article 142 or otherwise. So, that is a danger zone which needs to be looked into for this purpose, to avoid any such transgression into the rule of law itself, which is the basic tenet of the constitution and for the people. The third problem is the expertise which is required to be consulted. The people who are trained for that purpose, educated for that purpose, are there for that position, indeed to do that entire exercise which is required to make a proposition before one. The fourth, as Mr. Rothke was also saying, is this conflicting interest between diverse groups. What happens when a court passes an order? It's a finality unto itself, and there can be various times which one has seen where some interests may have been ignored. Now, what happens to that? Ultimately, the court is the guardian of everybody's rights, not only of one section. So, I think these are some of the problem areas which need to be looked at rather closely. So, in the name of filling in gaps in law or filling in gaps in the action by executive, I think we can have sometimes problems, and we need to relook at those things.
Sanjay Agde, comment on that, because Ms. Pinky Anand has raised some valid points. In the name of of filling gaps, can the use of these of Article 142 be justified? What about the competence on some of these matters? That would the courts be able, competence to sort of take these policy decisions, if I may say that? Also, the question of there is executive accountability. At the end of the day, politicians who take these decisions are voted to power, and if people don't like it, they vote them out. There is executive accountability. So, in the name of of gaps in legislation or gaps in executive action, how do you decide how much of space can the judiciary encroach upon?
That kind of answer is almost impossible to take. But it is
I think
Ms. Agde, to answer this question, I'll come to you in just a minute. Sanjay Agde, that's for you.
I'm sorry.
Sanjay Agde, that's for you.
See, this 142 thing, 142 is a bogey, because 142 powers cannot be used when there is a law on the subject. The Supreme Court itself has held that. In fact, on occasion, when it used its 142 powers and then realized that there was a law, it took back its judgment. That's the first point. Secondly, if there is any judgment which or order which grievously injures the public and which is against the law, the Supreme Court is also has the powers of review, and it on occasion does review its judgments. The recent national anthem case is an example where there was an order passed, there were review petitions and applications filed, and the Supreme Court is now trying to rebalance. Occasionally it may go overboard, I agree, but it has a self-correcting mechanism, and it's a self-correcting mechanism which is much faster than executive inaction or waiting for 5 years for an incompetent set of parliamentarians to be voted out. There are times when you cannot wait for decisions very long, and paradoxical as it may sound, sometimes it's the judiciary which has to step in and render a decision which everybody then follows and lives with. The question is, are we better off with judicial intervention, or are we worse off? I would be inclined to think that we are much better off. The occasional case where the judiciary gets it wrong, they have self-correcting measures.
Okay, you made a point. I think the other argument made on this whole issue of judicial overreach is that what happens when the court starts deciding on matters like who should run BCCI, or what should be the height of a dam, or or whether a state should not offer farm loan waivers, is that it probably, given the limited capacity, the shortage of judges, the pendency of cases, its priorities could get distorted. Mukul Rohatgi, what's your view on this?
Yes, it will distort the priority because people are crying for their cases to be decided. I mean, a man who loses a job or a man who's in jail and his appeal can't be heard is as important as anything else which is under the garb of a PIL entertained at the cost of these cases. Now, let me tell you, there are lakhs and lakhs of cases pending all over the country where people have put in 10 to 15 years or 8 years in jail and their appeals are not being heard. So now what is to happen to those cases? Therefore, merely by increasing the number of judges is not going to help. So what you need to do is a structured look. You have to see from the government's point of view, you have to see whether the number of appeals are excessive. From the court's point of view, you have to restrict lengthy arguments. You have to hear in a short while, not deliver 500 or 1000 page judgment, deliver short judgments, and also look at priority of these cases. That's why I say a complete introspection is required as to what is happening. Otherwise, the system is virtually broken and whatever is left will also break in the next few years.
Mr. Sorabji, I want your views on this issue of capacity constraint and the fact that judgment like decriminalization of homosexuality of Article 377. Those are matters on which probably many would argue that the court should intervene and not intervene in issues like a highway liquor ban or urging a state to go in for a farm loan waiver or on who should run BCCI. Do you think that this, in a sense, distorts the priorities of the judiciary? Mr. Sorabji.
Look, judges have not been given the gift of infallibility. Judges may go wrong. Sometimes Article 142, the directions passed are a bit bizarre. But the question is, on the whole, what do you do? If there is executive inaction, what does the judiciary do? Fold its hand and say we won't do anything, look the other way around? Take the conditions in India on the ground and see the role of the judiciary in that context. I repeat, it can go wrong, but it has also corrected itself, as has been pointed out. I don't understand how 9 judges and 11 judges in the legal audit will really help matters. It is really the sensitivity of the bench to the violation of the human rights, fundamental rights of the people, especially of the lowly and the lost. If they have no remedy except by judicial intervention, and the judiciary intervenes in that matter, all the good. Let me tell you one thing. In Vishaka, sexual harassment in the workplace, you know what the Supreme Court said? The directions which we give will hold good till Parliament enacts the law. I think that was a very good thing that pointed out that when the Parliament enacted the law, keeping in mind the directions of the Supreme Court about what constitutes sexual harassment, how it should be dealt with, then these directions won't hold good anymore till Parliament makes the law. Now that's the correct approach. It happens, it's not followed in every case, but please don't say for that Article 142 jurisdiction should be curtailed or Supreme Court must not intervene in matters which really enhance and protect the fundamental rights of our people.
Okay, fair enough. Ms. Pinky, let's talk about solutions. Just 4 minutes left on the show. Ms. Pinky Anand, coming to you. Mr. Venugopal, the Attorney General has made a case that all, cases invoking Article 142 should be referred to a 5-judge bench. Mr. Rohatgi, for instance, believes it should be referred to a 9-judge bench. If anything, what's your own view? Is that a solution? Will that, in a sense, instill some sort of a check and balance to ensure that this doesn't get abused?
The point is, ultimately what was argued in the matters which took place recently was the fact that you have this constitutional demarcation, and the various spheres should work within their spheres to ensure that there is quality of justice to the people. So the real interest is ultimately people. The reference to a larger bench would definitely ensure that when directions are to be given under 142, and 142 is a substantive provision of the Constitution which ensures substantial justice for the people. There is no question that it should not be available, but the instances in which it should be available, the situations that it can tackle or should tackle is also a matter of extreme concern, and where the line should be drawn, so to say, the Lakshman Rekha again for intervention. So referring to a larger bench would obviously ensure that you have a larger thinking on the subject and address of all the stakeholders concerned to ensure that only such orders are passed which are absolutely essential and which do not transgress these limitations.
Sathwik Verma, another suggestion made by the Attorney General is that the government should bring out a white paper, to study positive and negative effects of its judgment after 6 months, for example, on the case of highway ban or in the case of the cracker ban, the highway liquor ban or the cracker ban or issues like this. 6 months into it, the government should probably come out with a white paper that says how many jobs were lost, how many, what is the revenue implication of it, what was the beneficiary, did the highway liquor ban really bring down the accident deaths in the highway, do a sort of positive negative analysis, present a white paper. Is that something that you think could help bring about more accountability in general in the system? Sathwik Verma?
I think, for one, I think it's extremely impractical because I'm not sure how exactly does one measure the effectiveness of the implementation of a judgment. Let us, for example, take the case of the banning on only sale of firecrackers in Delhi. I think it was a very, very well-intentioned judgment. It was a judgment that was, perhaps necessary, but we also know from all the media reports and the studies that were carried out that this year the reason for the drop in pollution was not solely on account of there wasn't very much of a drop, Sandeep, and whatever drop it was not only on account of the fact that there was lesser firecrackers that were burnt and not sold, because people were bringing them out and buying them from different parts. But the studies revealed that it was on account of various factors, the foremost amongst them being that Diwali this year was much earlier in the season, and at that stage the speed of the wind was much different. So I think it's going to be extremely difficult to try and, I think it's a well-intentioned thought to have a white paper, but I think from a practical perspective, it's going to be very difficult. Unlike that, a judgment like, for example, the liquor ban, we had a direct effect of that. Jobs were lost, and also bear in mind, people, I'm sure we all saw photographs on the internet that because of the straight line, people went around opening an entrance in a zigzag manner, which was only a way to circumvent the implementation of that judgment. And, as a practitioner, it hurts us because it demeans and brings down the sanctity of the rule of law. So I think we do need to make sure that the judgments that are passed are effectively implemented. I'm really not sure on, how practical a white paper and what are going to be the contours of measuring the success of implementation of a judgment.
Okay, 30 seconds, Sanjay Hegde, and then I'm going to give the last word to Mr. Sorabji. How does one draw Lakshman Rekha for the Supreme Court, and should one draw that at all? Because, how do you define what is a distinct line that separates the powers of the judiciary and the executive and the legislature? How does one draw a Lakshman Rekha?
It is wrong to think of Lakshman Rekhas or watertight compartments in terms of separation of powers. Each era, each time, it draws its own Lakshman Rekhas. Sometimes you have governments which are not very effective. That's when the judiciary has to step in. Sometimes when you have effective governments, judiciaries do have a hands-off approach. Each judgment is often a product of its times. We must trust to the goodwill both of the judiciary as well as of the government, and the most important thing is that all these organs of government have to realize that they are not in an adversarial role to each other. We all serve under the Constitution, we all serve the people.
Mr. Sorabji, you're the veteran. You've seen this battle play over years and decades. Your view on the Lakshman Rekha and the point that Mr. Hegde made, which is at the end of the day, all these organs need to realize that they don't have an adversarial relationship. But this conversation that happened yesterday in the court between the Attorney General and the Supreme Court, the senior most judges in the Supreme Court, gets a feeling that it is some sort of an adversarial relationship at play here. Your view, sir?
No. Each judge must have his own Lakshman Rekha. And the main thing is, it must be realized in these matters, it's not against the government, it's not an adversarial role, it's a role together with the government to see that the fundamental rights of the people are enforced, enlarged, and made a living reality, and don't become merely on paper. That's the main thing. How you do it all depends on each individual judge, and you can't really have the Lakshman Rekha in that sense for each individual judge. They may go wrong, they may not, but on the whole, judicial intervention is much preferred, even if sometimes unnecessary or unwarranted, than judicial abstention. That's my firm view, and I hope that our judges will, of course, realize that they do not have the power to intervene in many policy matters. But even so, ultimately, is this realization that what matters are the fundamental rights of the people and they have to be enforced and protected.
All right, on that note, I'm going to thank my panel, Mr. Sori Sorabji, Mr. Mukul Rohatgi, Ms. Pinky Anand, Mr. Sanjay Hegde and Mr. Satvik Verma. Thank you so much for joining us on this edition of the India Development Debate as we debate the Lakshman Rekha for the Supreme Court. Now, the debate on judicial overreach has been going on for years. What that tells you is that it is indeed very difficult to draw a Lakshman Rekha on the separation of powers between the executive and the judiciary. Now, while the independence of judiciary is paramount, there is definitely a case for the courts to introspect on whether it's doing justice to its own judicial capital. Thanks for watching this special edition of the India Development Debate.